Thank you very much. It is not easy to continue after such a brilliant panel in the morning. It was really fascinating to get all the presentations in that panel. Actually, it was so fascinating that Mark already answered some of my questions, which is great because I can connect to your presentation and to all the others in the previous panel. I can share some doubts and some questions regarding that particular issue of horizontal regulation of platforms. So the title of my presentation is How to Regulate Platforms, the downside of the risk of technology-based horizontal rules. In advance, just some expectation management in connection with my speech. I don't give an answer how to regulate platforms, but I would like to draw a narrative and to share some thoughts and doubts about the new horizontal regulations regarding these internet platforms. Mark already talked about this, that is a new phenomenon that we now have, and we will have more horizontal regulations. I will want to connect to that part of the discussion today. We already have some serious experience here in Europe, thanks to GDPR, which is itself a horizontal regulation. And we already have important new draft regulations. So we can see likely outcomes of current regulatory works on the EU level. Now I'm speaking about, it's cherry-picking a bit, I'm speaking about the Digital Services Act, and I will speak a little bit about the draft regulation on artificial intelligence. I was happy that Mark also listed it as an important horizontal regulation. I won't go deeply in this regulation. It's a new draft, and it's a different topic, but with serious relation to platform regulation. And I can use it as a third example for my narrative today. So my narrative is based on an interpretation of this sort of chain of regulations on new technologies. I won't be comprehensive at all, just try to stress an important point regarding our regulatory approach. I try to drive attention to crucial differences between certain approaches regarding platform regulation. I think, and it is for sure, that in Europe we already took and are taking very serious steps in order to answer the challenges we face regarding these platforms we're talking about yesterday and today. We're currently working on very new, serious regulations. But I want to emphasize that if we do not focus on the substantive social questions that are raised by these very platforms and that are the main challenges to our societies, that we cannot reach our goals and cannot protect our public values, even with the most elaborate regulations. It will be clearly an oversimplification, and to be honest, I will be more than happy if you challenge it during the Q&A and if you convince me that I am wrong on some point in my presentation. I believe that interpretation can be drawn in this regard that our rules and horizontal rules and draft horizontal rules for the time being miss some crucial questions to be addressed because they are focusing on and try to regulate technology, the pure use of technology itself, and not the social role, the social impact, and the public values in question. I'm not saying at all that they are not touching upon and not regarding relevant values, but I am arguing that they are not addressing some of the main social questions. And maybe it will be a question of national regulations, but then my narrative is a warning for national lawmakers to do that in the future. Two short clarification in advance. First, what do I mean by focusing on technology, so regulation focusing on technology? I see some production of the EU regulation or EU regulatory works, GDPR, and some new draft, the DSA, the Digital Services Act, and the AI Code, draft regulation on artificial intelligence, as rules regulating the technical tools, the processes, and instruments used by online platform providers. On the one hand, it is completely reasonable, since we are talking about tech companies here and operating through new technologies, so of course we cannot regulate them without regulating the technology they use. On the other hand, the whole discussion that we have had for years is about that the phenomena that these companies have by now got very far from being only tech companies. They are much more than platforms in a neutral technological way and sense. They are the new coordinators, as Zsolt called them in the morning, new gatekeepers, we usually call this name for them, or even new governors, as for example Kate Klonick labels them in the United States, of our individual and social life. So they are operating with tremendous impact on our societies for sure. I am arguing that rules focusing mainly or maybe only on technological questions by definition cannot be enough to address some of the main social and democratic challenges. And the risk, sometimes a problem itself, that once we have our European horizontal instrumental code and regulation, lawmakers tend to think that we solve the problem because we have a code on artificial intelligence, we have a code on platforms, we had a code on data protection, a regulation that is binding for all the member states. And I would say that this is not the issue. We didn't protect some of the most important social values with these regulations. My second quick clarification, what do I mean by horizontal? Mark already used this adjective in the same way. Horizontal means that regulating every or almost every use of the technology, not sectoral, not in a sectoral way. So regulating the use of technology, the process or the instrument in question, that is the subject of the regulation, based on the fact that this technology, this instrument is used in a way, but irrespective of sectoral features and specific public values. And just one more remark in advance that I already mentioned, that I well know that the competencies of the European Union have their own limits in regulations, and substantive social issues are usually up for national regulations, but there is still the risk I mentioned that the national regulators will think and will point to the EU horizontal codes that we are done to some extent, and almost entirely we are done because we have a binding regulation, not just a directive, but a regulation on the very same issues. So after this introduction, let's see what I'm talking about. I will have these three examples, and I hope that they will be enlightening what my narrative is about. My first example is GDPR, which is the best because it is already in effect and we have some experience in connection with GDPR. GDPR is, I think, by now one of the most significant and characteristic regulations of the European Union. It is not a coincidence that Europe, the Union, was the first to take a major step to protect our personal data on the ground of human dignity. Although we have serious debates on other components of human dignity and the legal notion of human dignity, it goes without question that data protection should be included. So it's the GDPR is about. GDPR is a huge step forward regarding the protection of privacy, First of all, it had and has an irreplaceable role in increasing data protection awareness throughout Europe, moreover, to some extent, all over the world. Second, GDPR is actually a proper answer to a whole bunch of data protection issues. It is for sure, it goes without question. We can say that the EU became a standard bearer of the topic with the GDPR, which is a huge achievement. However, we should also recognize, I would argue, and admit the limits of this regulation, the GDPR protection. And we should clearly identify the challenges it cannot properly handle. I see the issue of platform regulation just as such a challenge from the perspective of GDPR. Interestingly, for me, at least, the best way to formulate the weaknesses of this approach of the GDPR comes from the US. I find the terminology of Professor Robert Post appealing at this point. Post makes the key difference between data privacy and dignitary privacy. He made this clarification in a specific context, namely interpreting the Google Spain decision of the European Court of Justice on the right to be forgotten. But I strongly believe that this differentiation is enlightening more broadly, and I can use it for my purpose today. So GDPR regulates the processing of personal information to ensure that such information is used only for specified purposes for which it has been collected. Data privacy operates according to an instrumental logic, and it seeks to endow people with control over their personal data. GDPR defines personal data and processing of data in expansive terms, so it horizontally covers all activities involving data processing as such. It works well and sufficiently in a whole bunch of situations that are constructed by the same concrete instrumental logic. That's the main thing to me, that it is the instrumental logic in this. GDPR can protect data privacy in these situations, which is a huge achievement. But what about domains and activities and service providers that are not constructed according to this more narrow instrumental logic? In this case, the possible harms on our private life are way more complex than data processing. The alternative notion of dignitary privacy means that in situations which are not constructed according to this instrumental logic, we need to focus on other features than technical processes and instruments in order to protect the inherent value of human dignity. We have to find new solutions for protecting dignitary privacy. I find online platforms as such services that are challenging the approach of GDPR. In terms of data processing, they are not operating in a narrow instrumental logic. The business model of these online platforms, Professor Balkin talked about it very deeply yesterday, is about providing free services in exchange for the right to collect and analyze unforeseeable amount of the personal data of an unforeseeable nature. Endless surveillance, meaning the infinite collection of digital personal data, is in the core of this business model. GDPR relies on securing privacy by obtaining end-user consent to transactions. There are more implications that this is the core of the model. It works very well in this instrumental logic again, but it is insufficient when it comes to endless and unlimited collection of data, and when end users are completely unable to assess the cumulative risks of granting this permission to data processing. So, when we are talking about online platforms, I would say that GDPR cannot effectively address the specific business model according to which they operate. It is important that GDPR covers their activities, of course, but it cannot effectively address the problem. It is not able to react to the very new nature of these services. In this context, GDPR only tries to protect data privacy, and it can protect it, and it is a big deal in itself, but is chanceless, or at least it's way not enough to protect dignitary privacy, the actual private life of people. What can be a solution, you can ask. We for sure have to focus on the unique role, social role, and that these online platforms achieve with their services. One possible answer that we heard yesterday from Professor Balkin is the information fiduciary model. I do not want to go deeply in this because he just spoke about it, and you may also know his work on this model. But I want to underline its very different approach. Instead of regulating technological instrumental processes themselves, it faces the challenges that these platforms raised by their very new business model and social role. In a model like this, for example, the information fiduciary, it's a US model, but mutatis mutandis, we could use it as a model in Europe as well, I think, for the purpose of future regulatory works. In a model like this, obligations of the platform do not depend on whether the user gives his or her consent or not to a process, to a data processing that he or she may never get to know precisely, but depend on loyalty rules based on the role of platforms. Platforms have to be loyal to their users and cannot do anything against the privacy interests of their users, not because they do not have the consent yet, but because they are not allowed to do that according to the rules tailored to their special operating model and new social role. I see it as it is far from the instrumental approach of GDPR, and it can be something that as a supplementary solution to the GDPR. Let's see whether the new draft regulation addressing the very subject of online platforms after GDPR is not addressing the platform problem itself, but the subject of online platforms or in the DSA, the Digital Services Act. Let's see whether it is an adequate and enough solution. My answer will be, again, that not in itself. So in the last couple of years, regulators turned to the special problems raised by online platforms, as we heard it in a comprehensive way from Mark's presentations. EU has its own proposal that is promising a comprehensive solution. The explanatory memorandum of the draft regulation gives the reasoning for its rules, saying that EU institutions recognized the particular impact of very large online platforms on our society and economy, and they want to set a higher standard of transparency, accountability, and the protection of fundamental rights. No question that the draft regulation takes serious steps in order to secure important public values, first of all, the value of transparency. It puts a bunch of obligations on platform service providers, just a short list that is not exhaustive, notice and action mechanism, transparency reports, internal complaint handling system, out-of-court dispute settlements, statement of reasons to users, very important, measures against misuse, risk assessment, appointing compliance officer, and so on. These are very serious measures, very serious obligations that address some of the problems. But my concern is, and my doubt is, that the draft regulation does not address some of the most pressing issues stemming from the special role of platforms. Again, maybe it is up for national regulators, but then it is a warning for them. If you check the list I mentioned, the list of obligations in the Digital Services Act draft, you can see that service providers need to take very detailed procedural and technical obligations. But I see these obligations, again, have an instrumental logic that is good for some purposes, but insufficient to address the substantial social impact that platforms have by now. Transparency is a first step, but we already know that the problem is deeper than knowing more about how they operate. The issue is that they should operate some ways, and they should not operate other ways if we want to keep and protect our public values. So for the purpose of my narrative today, transparency is just a technical starting question and issue, but not the substantive solution. Let's see two examples, both coming from the field of free speech. The first is content moderation. We have very detailed procedural rules, and we all should welcome these rules, but where is at least a principle, a substantive principle that expresses the new role of platform providers as possible gatekeepers? A provision like that would and should limit the room for moderation, I would say. It should make it clear that it is not only a question of their terms and conditions, how they moderate or ban certain speakers or content. We have our reasoning for that in our European constitutional doctrine. This is about the horizontal effect of fundamental rights. If I am right, we will hear about this very important constitutional concept from Professor Policino, probably. So we should address this substantive issue. My other example is also free speech related, the recommender system of these platforms. We see transparency rules again, very important. But transparency is just the beginning of the problem. By now, we can clearly see that these services reshape the whole structure of our public discourse. Where are at least principal rules, turning them into a direction, a new direction? Some provisions limiting their freedom to operate such recommender systems. To be honest, I do not see these rules for the time being. Maybe we should see it in future regulations or in national regulations, but let's wait for that. Although without these kind of rules, we do not touch the very essence of their social impact on public discourse. And my last example, as I mentioned, is the new draft regulation on artificial intelligence, which is not about platform regulation, but it has serious relations to that. And as I see, it is supporting my narrative today, so I will use it. I do not examine in details the draft AI regulation of the EU for two reasons. This is a very new draft. It can be modified in many ways. It is under the discussion now. And second, the topic of AI could get us in a very different directions if I would go deeply in this. But I think that we can put this draft in our list, resulted from certain regulatory approach in connection with regulating new technologies. As we can see and we can predict, seeing this new draft, we will have, again, a horizontal code, horizontal rules on new technologies, in this case, on AI applications. On the one hand, we can certainly say that it is important to handle the specific new challenges we face due to AI tools. On the other hand, there is a risk, again, to me, that we will be satisfied having one comprehensive horizontal code regarding AI. But with one horizontal code, we can regulate only technology itself. and not the special social impact that one or another AI application can cause. Common horizontal AI rules will inevitably have a so-called technical or instrumental approach again, because it is the technological background alone that connects, for example, Google search algorithms to law enforcement predictive systems or to AI applications as diagnostical tools in the human healthcare system. I know that there might be common risks rooted in the technology applied, but I do think that our main target should be the unique impact of different mechanisms. Technology, in this case AI, appears in very different spheres and affects very different constitutional public values, very different social values. Variety of values are relevant in the healthcare system, in the labor market, in the public administration, or in the public discourse. The real question is whether our new technological solutions, codes, and algorithms promote or destroy those specific values, social issues in specific social spheres. But we will not be able to address these basic challenges if we do not turn to these very specific substantive questions. So, my conclusion, that we have serious achievements in Europe regulating certain risks of new technologies, and these regulations affecting online platforms, not just the platform, not just DSI, but other horizontal regulations. But we might miss the main target if we keep our focus only on horizontal, instrumental, technological questions. What we need instead is an approach focusing on special social impact of different applications of the very same technologies. So back to my title, that was the downside or risks of technology-based horizontal rules. I would say that the risk or the downside that we might not react to important social challenges despite of having huge regulatory costs on technological developments and applications. I'm not saying that I know the solution today. It was good to hear that in the Q&A session after the last panel, the presenters also admit that we don't see any good solutions now, but I think that a good solution starts with identifying the good problems. I try to add to this process with my presentation. Thank you very much.